Hello and welcome to Hull and Estates. You're listening to episode number 539. I'm Stuart Clark.
And I'm Nick Esterbauer.
So today we're going to be discussing some Estates Law 101 in the form of Saunders and Vautier. But before that, hi Nick, this is the first time we've podcasted together, so that's an exciting new development.
Very exciting.
And we have this new setup here for those watching online. I'm in a high back chair here. I feel like I should be lounging fireside with a drink, discussing Estates topics of the day. Saunders and Vautier. It's a term that's thrown around a lot by estates lawyers, often with the foregone kind of assumption that anyone hearing the term must instinctively know, oh, Saunders and Vautier, of course that must mean X, Y, or Z. That's not the case. It's a term that's fairly basic and fairly, important to the variation of trusts and administration of estates. But the question is, does everyone actually understand what that means?
Right. So Saunders and Vautier, it's a case from 1841. It's a decision of the High Court of Chancery. And in that decision, you're dealing with a beneficiary and a will that says that that beneficiary is not entitled to this specific bequest until he reaches the age of 25.
Exactly. And I remember in law school when the term Saunders and Vautier came up, it's exactly that scenario that was discussed. And the scenario is, a trust or a will is established, and it basically is a bequest to an individual saying, to Nick, I leave $100,000, but it's not to be paid to you until you're 25 years old. Well, when, I die or establish a trust, you're only 20 years old, so in theory, you don't get that money yet. But if that bequest or trust doesn't contain a gift over, so if it doesn't say, to Nick when he's 25, but if Nick dies before he's 25 years old, then to Steve, the basic concept of Saunders and Vautier says, well, Nick can collapse the trust and essentially demand the payment right now, notwithstanding the fact that he's not yet 25 years old. And when you hear people throw around Saunders and Vautier, it's often in that scenario. The scenario being, you get property when you're age X, there's no gift over, so therefore you can get the money before you've turned that age, basically when you turn 18 years of age. And that's when you often hear it thrown around, but it would be a mistake to assume that that is the only scenario that Saunders and Vautier can be applied. It's actually a much more expansive concept than that. And I think it would be a good kind of refresher for us to kind of go through more expansive role in understanding what Saunders and Vautier means.
For sure. And I wonder if before we jump into that, if we just take a quick look at the decision itself and the considerations that the court made at that point in determining to terminate the trust in favor of the beneficiary. So you've got this 21-year-old beneficiary. He's entitled to the asset at age 25. And the court looks at, of course, is there a gift over clause? No, there is not. The court considered there to be an immediate gift because the asset to which the beneficiary was entitled was to be segregated and held in trust for him. The court also looks at the wording of the will itself, and that the transfer was being made to the beneficiary, to his executors, administrators, or assigns. So the court did consider at that point, and really that's the extent to which they do consider the intention of the testator in providing that gift to the beneficiary.
Mm-hmm. So if you could step back, and what does Saunders and Vautier actually mean from a very wide, kind of trust and estates law implication standpoint? And I basically think it kind of is, the rule of Saunders and Vautier is the rule which allows a beneficiary to vary the terms of a trust. Whether that trust be a trust that we talked about before, like the actual case, i.e. you get this property when you're 25, no gift over, therefore you collapse it now. And the basic concept is that if all beneficiaries collectively representing 100% of the ownership rights of that property, so if there's one beneficiary in the case of when you're 25, it's just you saying, I want the property now. If there's two of you, if you both get together and say, no, we want it now, the trustees basically have to act in accordance with the wishes of the beneficiaries, and the trust is collapsed. So Nick a second ago mentioned the fact that you can kind of the intentions of the testator or the settler in establishing this trust or estate. It's kind of flowing around in here. But case law over time has clearly stated that in invoking the rule of Saunders and Vautier, the intention of the testator or settler, it doesn't matter. All that matters is all beneficiaries collectively say, we want the money now, we want to vary the trust and do this instead. And the trustees basically have to act in accordance with the instructions of the beneficiaries, regardless of whether those instructions go against what they believe to be the intentions of the testator.
Right. So I guess in some circumstances, the result is going to be something different from what the testator intended completely. So even though there may be an intention expressed that some asset is held in trust for a beneficiary until they reach a certain age, as long as that person is old enough and able to consent to the immediate distribution, they can go ahead and apply for that.
You know, exactly. I mean, you can almost think that the rule of Saunders and Vautier is almost designed to ignore the intentions of the testator, because the intentions of the testator was you don't get this property until you're 25 years old, but you want it now when you're only 18. Well, you're basically ignoring the intentions of the testator at that point, but you have the right to do that because you're the only person who could ever get that property. The court has basically said, well, you can demand it now and ignore the intentions of the testator. As mentioned before, the rule of Saunders and Vautier can apply in circumstances where there's more than one beneficiary, and in circumstances where there's income beneficiaries, capital beneficiaries, multiple classes of beneficiaries, so long as every beneficiary who could ever take under that trust or will consents to it. If even one beneficiary, regardless of how remote their interest is, says, you know what, no, I'm not prepared to agree to collapse this trust now, I'm not agreeable to vary it the way you want this done now, the whole thing falls apart, and there's no ability to force that beneficiary to consent to the rule of Saunders and Vautier. And if that happens, you're basically stuck with the trust or bequest as written, and the trustee has to continue to administer it as settled.
Right. So you do need the consent of all the beneficiaries. It's 100% of the people interested in that gift or with a contingent interest in that gift. And in order to consent, these people have to have legal capacity to do so.
Exactly. And that's an interesting segue, actually. So Nick mentioned that you need to have legal capacity to consent to this. So that, of course, raises the question, well, what happens if they don't? What happens if, for example, one of the beneficiaries is a minor or is an unborn beneficiary, to my issue, and the issue could theoretically go on forever? How do you, or can you, still invoke the rules of Saunders and Vautier and collapse the trust or vary the trust if there's a beneficiary in the hypothetical world of this trust who does not have capacity, legal capacity, whether it be a minor, or otherwise? And the short answer is yes, you can still use the principles from Saunders and Vautier, i.e. if you get all beneficiaries to consent to the variation, it can still be varied, but to get the consent of that party under disability, you need to proceed under what's known as the Variation of Trust Act. And that basically gives the court the power to step into the shoes of the beneficiary under disability and consent to the variation on behalf of that beneficiary. And the Act says the sole question to be asked in determining whether to approve it is there a benefit for that beneficiary? If yes, the court can approve it. If no, then obviously it won't. And if the court does approve it, and all other beneficiaries who are, with capacity have already agreed to the variation, everyone's agreed to it, Saunders and Vautier is invoked, and hey presto, trust varied and collapsed.
Right, so that sounds to me a fair bit like a motion for court approval of a party under a legal disability.
No, it's exactly right. It's very similar, same concept, where basically the court's being asked to step into the shoes of the party under disability and ask, is this for their benefit? And they have the authority to consent to it and approve it. But that, of course, is a conversation for another day. The Variation of Trust Act and the case law that goes along with that itself could be a podcast topic, so maybe that could be one for another day. But important thing for here is that the concept of Saunders and Vautier can be used, even if there's a party under disability. You just have to go under that act. But I think that brings us to the conclusion of today's podcast. So we want to thank you again for listening. And until next time, I am Stuart Clark.
I'm Nick Esterbauer.
And if you have any questions, please feel free to email us at webmaster@hollandhall.com or leave us a comment on our blog. Thank you, Nick.